Again, good afternoon or evening, depending on where you are based. This is our 6th webinar on international human rights monitoring mechanisms. For those of you who have participated in our previous webinars, this will be repetition, sorry. But for the first timers, let me introduce myself, Etkiniz, and our guest for today's webinar. My name is Adem Arkadaş-Thibert'in. I'm Human Rights Monitoring and Advocacy Key Expert of Etkiniz EU program, a relatively new and innovative EU support program for civil society organizations in Turkey. It provides support for civil society organizations for monitoring compliance of Turkey, with the international human rights framework, mainly the United Nations, Council of Europe, and Organization for Security and Cooperation in Europe. Etkiniz program strives to help civil society organizations in Turkey to increase their access to and influence to European and international human rights frameworks and mechanisms. Today we are going to talk about reporting the state of civil and political rights in Turkey to the United Nations Human Rights Committee, because the Human Rights Committee is going to prepare a list of issues before reporting to the Turkish authorities. In this period and hereinafter, civil society organizations are going to have opportunities to engage in a constructive dialogue with the UN Human Rights Committee. And our guest speaker, Làzarie Eeckeloo, is going to talk about these opportunities. What is the UN Human Rights Committee? And how can civil society organizations in Turkey may get involved with the Human Rights Committee? Làzarie is a human rights officer at the Center for Civil and Political Rights and focuses on thematic work as well as specific countries, including Turkey. This includes the link between the corruption and human rights and the situation in Mauritania and Kenya as well. She holds a law degree from the Catholic University in Leuven and an LLM, a law degree in international humanitarian law and human rights from Geneva Academy. Her thesis focused on the implementation of Human Rights Committee recommendations on the ground in countries. She previously worked at the Belgian representation of the European Commission in Brussels. Now the floor is yours, Làzarie.
Thank you very much, Adam, and thank you to the Etkiniz program for inviting me to speak. Thank you to everyone who is attending this webinar. It's nice to see there is so much interest on the side of civil society. I will try to speak for about 40 minutes and then leave some time for questions. So as was said, you can put your questions in the Q&A box. And I will now share my screen so you can see the presentation. And you will receive the presentation after the webinar today. And as you can see, it includes my email address. So if after the webinar you still have questions, don't hesitate to contact me on there. Maybe first explaining a little bit of who we are. So as was said in the introduction, I work for the Center for Civil and Political Rights. We are an NGO based in Geneva. We were established in 2008, and our vision is, or our goal is to strengthen the participation of civil society at the Human Rights Committee, and sometimes more generally to other human rights mechanisms as well. And in that sense, I think the goals of the CCPR Center and Etkiniz program align very well. What do we do concretely? We basically divide our work into 3 phases. There is before the review by the Human Rights Committee, during the review, and after the review. Before the review, we try to prepare civil society, and this is where this webinar comes in. We are currently before the review of Turkey. We support civil society during the review with, for example, briefings to the Human Rights Committee members. And after the review, in some countries, we also focus on follow-up and trying to get the authorities to actually implement the recommendations they have received. We'll focus on 3 subjects today. I don't know if we'll really have time to go into everything, but as I said, you'll receive the presentation later. So you'll have all the information. We'll first look at the Human Rights Committee more in general, then look at where is Turkey with the Human Rights Committee, and then look at individual complaints. Just to give a broad overview of where we are, in regards to the UN, the UN has agencies like UNHCR, like UNICEF, for example. Then there are the political bodies of the UN, like the Human Rights Council, where it's states arguing with other states. And then there is the treaty body mechanism, where independent experts review the situation in particular countries. And we are focusing today on this treaty body mechanism. Yes, so there are 9 core human rights treaties. So I won't go through all of them. What is important to know is that the International Covenant on Civil and Political Rights is one of them. Some of them focus on particular groups, like, for example, the Convention on the Rights of the Child. Some are more broad, like more thematic, like the Convention Against Torture. And we will focus on the International Covenant today. So this is one of the core human rights treaties. It exists since 1966, and it has 2 optional protocols, and Turkey has ratified both. The first one allows for individual complaints, so we'll go into that later on. And the second one means that the state has abolished the death penalty. Some of the issues addressed in the ICCPR, so we're talking civil and political rights, meaning some of the important ones are freedom of expression, the prohibition of torture, the right to life is an important one. Non-discrimination is an obvious one. So I think most of you know what is meant by those important civil and political rights. And every treaty, so each of these 9 core human rights treaties has their own monitoring committee. And for the ICCPR, that is the Human Rights Committee. So the Human Rights Committee is the body that monitors the implementation of its treaty, the ICCPR. As I said in the beginning, we are talking about independent experts. So these experts are chosen because they have expertise in international law, in human rights law, and they don't represent their state when they're being a part of the human rights committees. And how do they monitor this? Well, from the moment a state has ratified the ICCPR, they have the obligation to regularly submit reports to this treaty body and explain what they have been doing to implement that treaty. So as I said, Human Rights Committee is the one we are focusing on today. It consists of 18 members. They meet 3 times a year for about 3 to 4 weeks each time. For the last year, they have been meeting virtually, and they will continue to meet virtually for a while. We hope by 2022, we'll go back to physical meetings, but I guess that's just how it is at the moment. They do continue their work while being online. How does that state review procedure actually work? So there are several phases, and everything starts with the LOIPR. LOIPR is a word I will use. It stands for List of Issues Prior to Reporting. The list of issues prior to reporting is a list of questions that is addressed to the state. So it's the committee asking to Turkey, what have you been doing to make sure there is no corruption? What have you been doing to guarantee the freedom of movement? All these types of questions. And then the state replies to that, and the reply is called the state report. When the reply is received, the Human Rights Committee will schedule in a dialogue. And it's a dialogue between representatives of the state and members of the Human Rights Committee, where essentially the same type of questions will be asked, but now in an oral fashion. And it will ask clarifications about the things that they have read in the state report, for example. Then after the dialogue is done, the Human Rights Committee will write up recommendations. So they will say, please, well, they usually don't say please, they say the state should guarantee, I don't know, freedom of movement for all people, including some vulnerable groups, for example. So they really recommend the state to do something concrete to improve their implementation of the ICCPR. And that is where the implementation phase starts. So the entire up half of the slide is the implementation phase. And this is also the phase that takes the longest. A review period right now is on average, I think, between 6 and 8 years. Because so this is a cycle. So the Human Rights Committee will specify in the document that contains the recommendations when the next report is going to be scheduled. So it's a cycle. So this thing is repeated over and over again. And the implementation phase is the longest phase. So this is basically the fundamental idea of the review procedure. What is this LOIPR? I've added an example in the slide. As you can see, I think it's an example from the LOIPR of Zimbabwe. So as you can see, please provide information on the measures taken to ensure that the state party's anti-discrimination legal framework provides A, blah, blah, B, blah, blah, C, blah, blah. And it's quite detailed in nature. So the Human Rights Committee does its homework, reads reports, including from civil society, but we'll get to that. They read background information, they do their own research, so they know what are the important laws to focus on, what changes have been made recently, and civil society plays a big role in that. It highlights what the priority issues are for the review, detailed questions, and this is what the state needs to reply to. And this whole thing forms the basis of the review, which is why it is important for civil society to get involved now, because you have now the opportunity to provide input to the Human Rights Committee for this LOIPR, for this list of issues. Where can civil society actually be involved? Basically throughout the whole cycle. I've put some arrows here and there, but you can remember any time in the cycle, civil society has their role to play. We're currently right before the LOIPR, so this first blue arrow is where civil society can participate, because as we will see, you can submit a written report to the Human Rights Committee. But then when the LOIPR is published, as I said, the state needs to reply to that, but civil society can submit an alternative report to the Human Rights Committee as well, answering to those questions from their point of view, from your point of view. During the review, you can participate in briefings with committee members. And after the review, obviously, you have a crucial role to play in getting those recommendations implemented at the national level. So basically, throughout the review, you are a crucial factor that can really improve the quality of the work of the Human Rights Committee. Now, how exactly? What can you do at this point? So we are now before the review, before the LOIPR has been adopted. You can identify priority issues. And that I would say is most important for civil society who is focusing on a specific theme that might sometimes be overlooked. So I saw in the participants list, some of the organizations present today focus on LGBTI issues. And those are really important because I'm not saying the Human Rights Committee has a tendency to overlook them, not at all, but it can be important to transmit to them a certain specificity of the situation of LGBTI people in Turkey. So if you focus on a specific theme, I also saw some people who focus on ecology. It's very important to include information on a, I would say like sometimes niche subjects, because you can then guarantee more attention to them. How can you get that attention? By submitting a report. So civil society can submit a report to the Human Rights Committee highlighting some of the main concerns. What we've also been doing, and that is quite new, is we also organize a briefing before the adoption of the list of issues. So we'll see that later on, but the Human Rights Committee will adopt the list of issues for Turkey in July of this year. So a few, maybe 2 weeks before the actual adoption, we will organize a briefing that will be open to civil society who submitted a report and the members of the Human Rights Committee, and you can have an informal discussion about what topics you think are important, what specific concerns you have, and it increases the chance for your topic to be included in the LOIPR. So that's also something you can do ahead of the adoption of the LOIPR. And in general, something you can do throughout the whole phase, throughout the whole cycle, is raise awareness about the process. In general, there is not much known at national level or at local level about the UN processes, even within government, for example. So sometimes governments receive recommendations, but after they have received the recommendations, they don't even get to the right government, like the right ministry in charge, for example. So if you can raise awareness among government representatives, among parliamentarians in your work, in the media, or with the general public, I think that's always a useful thing to do. Now let's move to part 2. So where is Turkey in this review process, in this cycle? So I said it before, so it's we're like before the LOIPR is being adopted. I will just complete the, so Turkey ratified the ICCPR in 2003, and then a first review took place in 2012. And now we're moving into the second cycle. So the second cycle will start in June with the adoption of the LOIPR. It's to be noted that, so there's almost 10 years between this first review and the second review, or there will be more. So there's a lot that has happened. So it's important to the time frame of what you report on should be between this first review and then the second one. So you can look at data from 2012 and later on, because that's the time frame the Human Rights Committee will be looking at. So 21st May is the deadline for civil society reports. And I realize that is very soon. But I would like to try to convince at least some of the organizations in the audience to still try to submit something. Why? Because as I said, if you submit a written report, it opens up the opportunity for you to take part in the oral briefing, which is really a very important opportunity, and it can be so efficient. You'll really go into a conversation with the members. You can stress what is important to you. And in our experience, we've seen that whatever the members of the committee hear in these oral briefings, they do take it with them in the next steps throughout the review. So I would highly recommend submit something. And my next argument would be, is that it doesn't have to be long. There is no minimum limit of information that the committee is asking for. So if you only have time to make a one-pager or to write, I don't know, 2 pages, or even like submit a report that was previously submitted to another body and you just slightly adapt the cover page, that'll do. The committee is always asking for information from civil society organizations because it helps them to balance out the information that they receive from the state. So if you contradict information that they have received from the state, they can ask in the dialogue. So you say this in your state report to the state, but we've received from civil society this. How can you explain this difference? So it is very crucial that the Human Rights Committee receives enough information from civil society. So I can only recommend, even if it's short, just submit something, your main concern, your top 3 main concerns if you don't have a lot of time, but at least something that gives you access to that briefing. And then the Human Rights Committee starts their session in the last week of June. I believe it's 26th or 28th of June. The exact date of when the LOI-PR of Turkey will be adopted is not known yet, and they are still working on the program of work. You can keep an eye on OHCHR's website or on our website, because we do usually publish that whenever it's available, but it will be in the course of July. So that briefing that I talked about will also take place in the course of July, in the first half of July. Now, what happens then? Because LOI-PR is only the beginning of the process, as we've said before. So then the state has up to a year to reply to that LOI-PR, and you will also have the chance to reply. Once the state reply is received, the Human Rights Committee will schedule the review of Turkey. So that's a dialogue that I talked about. And the deadline for civil society reports. So your reply to that LOI-PR is usually 6 weeks before the session where the dialogue will take place. Just to give you an idea, I don't think it's going to happen before 2024. It's difficult to give you an exact date because the agenda of the Human Rights Committee doesn't go that far into the future. It was originally scheduled in the year 2023, but due to COVID and the committee not being able to meet physically, they've met online. But the members of the committee are geographically all over the world, so they have time zone issues and they cannot meet that many hours a day. So the number of state reviews they have been doing is much less than regular. So I'm assuming with this backlog that Turkey's review will not actually take place before 2024. And then, as I said, when it's scheduled, the dialogue will take place and then the recommendations will be published, and hopefully you can use those recommendations in your work at the national level to get them implemented. So that's basically an idea of the timeline of where we are in Turkey's review. Now, drafting the report, some tips that I can give on what to include or what to pay attention to. So as I said, identify your priority issues, especially if they are a bit less common than, for example, torture. There are usually a lot of reports on torture, on non-discrimination, but if you work on a really specific group, for example, or a specific theme, or a specific event that took place that was important in your country's history, mention it. And update the committee on what has happened since last review. So for you, that would be 2011 and after. And what we also suggest, but of course it's totally up to you to decide, is it can be useful to suggest questions in your report. So if you're wondering about things, you can add these questions into your report as a suggestion, and the committee might take them and include them in the final LOI-PR, and they then are asked to the state, and the state should reply to it. So we encourage civil society to do that, as it can facilitate the work of the Human Rights Committee. If you formulate a good question, they can just take it as is and include it in the LOI-PR. Remember that the target of your report is the Human Rights Committee, and the members of the committee are all experts in international human rights law. They are not experts in Turkey's situation. So don't waste words on explaining what the definition of torture is, for example, because they know. but they don't know what specifically is happening in Turkey around torture, just to give an example. So focus on the situation in your country. Don't focus too much on the international law explanations. We obviously recommend that you write precise, reliable, objective, constructive information. If you mention statistics, for example, don't forget to add your sources so that it can be checked and members can know that it's a reliable source, for example. And something that is often overlooked by civil society, but can very much show what a situation is when information is not available, not accessible to the public. So don't just not mention that because it's not accessible, but explicitly say that you don't have access to that information, or that specific information is not being collected on that point. So we do recommend saying that. Or when there has been like totally no evolution on a specific point since the last review, mention that as well. Don't just leave that open. And of course, as with every report, keep it as concise as you can. There is a limit of around 50 pages or 10,000 words. If it's 10,100, the Human Rights Committee is not going to disregard your report because you went over the limit. It's more like a direction of please keep it to that amount. In that regard, we also recommend civil society to work together and to submit joint reports, as the Human Rights Committee gets a lot of documents they have to read when they prepare for a session. So if civil society can compile and just sort of all co-sign the report, it limits their reading. Now I know joint reports are also more work and the deadline is approaching. So if you think it's just not feasible to do a joint report this time, then submit one on your own. It's not like there's a prohibition on individual reports, not at all. And as I said, I think it's better that the Human Rights Committee receives some information from you before the deadline so they can use it when they are preparing the LOIPR. What kind of information should you include? Just very quickly, maybe. So as I said, they don't know the situation in your country. So if there was a happening, I don't know, something that happened in your country where you assume everybody knows about this, maybe don't assume and still explain, because it might be that outside your country, it's not that much known. Include statistics. They do paint a picture. If there's a sharp rise in torture cases, for example, mention them, but then mention the sources. Or if you collected the statistics yourself, explain your methodology. And this can be done in a footnote. Doesn't have to take up words. Mention case studies if you have examples of specific cases to illustrate things, if you've done research. If you do mention cases, as an annex, you can include the decisions or the court records, official documents, excerpts from the penal code. If something was reported in the media, don't hesitate to share the source of that media. Of course, only if that media is a reliable source. Pictures and figures. So if you mention statistics, don't hesitate if you have graphs to share them that way. As I said, members of the Human Rights Committee have a lot to read, so it can help, can make it easier for them to go through reports quicker if they have a visualization of what you're trying to say. Reports, you can refer to other reports of your own organization that you've submitted before, or reports of UN agencies, any reports that are reliable of other NGOs, don't hesitate to do that. And as I said, because of time constraints, don't hesitate to recycle reports or parts of reports that your organization has already drawn up, was meant for a different body, sort of rework them a little, and you can submit them as well, as long as the information is still relevant. And as I said before, it's just a suggestion. but you can include questions to the Human Rights Committee that they can just take over and put in the LOIPR. Are there any questions? Actually, I think it's easier for us if we do the individual complaints part first, and then I'll allow for people to ask questions, just because then we'll have had everything, and then we can go into questions. So individual complaints. As I said before, Turkey has ratified the optional protocol to the ICCPR, and that allows for individual complaints. That means that you, as a Turkish citizen, if you think your rights have been violated, you can submit your case to the Human Rights Committee. But there are some strict and quite technical and complicated conditions. So I'll try to go through these conditions. I'll try to simplify them a little bit. But if you have more detailed questions about this, or you're really actually thinking about a case, don't hesitate to contact me bilaterally after this webinar. I'll just drink a little bit of water before continuing. So here, I hope you can see, are some of the admissibility requirements. So before the committee actually goes into the case itself and looks at whether it was a violation, it will check some procedural requirements. And if those procedural requirements are not met, it won't even go into the case. And the first one is jurisdictional requirements. So there are some Latin terms. I'll go into those in the next slide more in detail. The second one is the exhaustion of domestic remedies. So the Human Rights Committee should be the last resort. So if you have a case where, just a general example, you were tortured by police and you think your rights have been violated, your first step needs to be to go through the Turkish court system. And once you've reached the last step, I don't know the Turkish court system. In most countries, there is a Supreme Court. So once you have a decision from your Supreme Court and you're still not happy, then you can go to the Human Rights Committee, but only then. If you've never gone through the Turkish court system and you immediately go to the Human Rights Committee, they will say, I'm sorry, your case is not admissible. The third condition is no simultaneous submission. So you cannot submit your case everywhere at every possible body and then wait like for the first one that actually makes a decision. You have to choose the body you want to submit your case to. So for example, I think for Turkey, you can either submit your case to the European Court for Human Rights or to the Human Rights Committee. You cannot do both at the same time. The fourth is no abuse of the right of submission. So I don't actually have an example for this, but it is specified in the conditions for cases at the Human Rights Committee. If it's clear that you abuse the right of submission, your case will not be admissible. And lastly, the fifth condition is a little bit of a technical one. And I don't actually know what the case is for Turkey, but states have the possibility to enter reservations when they ratify a treaty. So when Turkey ratified the ICCPR, they technically had the possibility to say, look, we ratified this treaty, but we do have a problem with, just to give an example, Article 25, and we don't agree with Article 25 on this point. Now, if you feel like your Article 25 was violated on that point, you will not be able to submit your case to the Human Rights Committee on that specific point, because your case is about something that Turkey said in advance, I don't agree with this. Now, just to be clear, this was an example. I have no idea if there is actually a reservation on Article 25, but keep that in mind. If there was a reservation, it won't be possible for you to submit a complaint really specifically on this topic of the reservation. Let's look at those jurisdictional requirements a little bit more in detail. Sorry. There's something that I need to discuss first. The one that submits the complaint should be the victim. The victim has to be a natural person. So if you have an association and the rights of your association, for example, were limited, you can never submit a case on behalf of your association. You will have to do it as a natural person. Within the jurisdiction of the state party, so Turkey is a state party to the ICCPR. You cannot, just to give a fictional example, if country X has not ratified the ICCPR and you're a national of country X, you will not be able to submit a complaint. And the victim should be affected by the violation, directly affected. So if your son, for example, was tortured at the police office, then your son has to be the one submitting the complaint. You cannot do it because your son was tortured. You have to be the one that was tortured yourself. And in terms of groups, just a little detail, every member of the group must authorize the complaint. And now to go into these jurisdictional requirements. So ratione materiae means that the complaint should be about a right that is guaranteed in the treaty. So for example, the ICCPR is about civil and political rights. If your claim is about the right to education, the Human Rights Committee is not your place to be. Now, it is important to remember almost all claims can be reformulated in a way that they do touch on civil and political rights. For example, if your claim is about the right to education and discriminated access to education, there you have the right to non-discrimination that is in the ICCPR. So it's just a way of looking at it and having the right perspective. Ratione temporis means that your claim has to be about a violation or an alleged violation that took place after the protocol entered into force for your country. So Turkey ratified the optional protocol that allows for individual complaints in 2006. So if you were tortured in 2003, it's just not going to work for the Human Rights Committee, except if we're talking about a continuing violation. And a continuing violation is, for example, an enforced disappearance. So if someone has disappeared in 2003 and they are still missing to this date, it will be admissible to the Human Rights Committee because it's a violation still today. And today, the protocol has entered into force. And lastly, ratione loci is that the violation must have taken place in the jurisdiction of the state party. And usually that would mean the territory of the state party. So for you, any violation in the territory of Turkey would be admissible for the Human Rights Committee. A little bit about the exhaustion of domestic remedies. So it's the highest national authority that you have to reach, except if domestic measures are unavailable, not possible, ineffective, or unduly delayed. I just wanted to mention this, there are exceptions to this rule, but it's still interpreted quite strictly. Just to give an example, unduly delayed, there are a lot of court cases being delayed nowadays because of COVID. And there is no precedent on this, and I'm just sharing my opinion. But I think that according to the Human Rights Committee, that won't mean that your case was unduly delayed, because in a lot of cases, the state just wasn't able to organize everything within the sanitary measures. So they will look at domestic remedies quite strictly. And it is quite important that every stage has been gone through. if you do submit a complaint, it's also important to add a history to it, so that it's clear for the Human Rights Committee what stages you have gone through and at what time. Now, about the time limit to submit complaints. So if something has happened, you've gone through the domestic remedies, is there then a time limit? It depends on the treaty body, because a lot of treaty bodies have this individual complaint system. And it goes from 6 months as a time limit to no time limit at all. Just as a general rule, just do it as fast as you can. Then you won't be struggling with this specific aspect. If it's significantly delayed, the Human Rights Committee might decide that it is inadmissible. It's not an exact rule. It's not very, very strict. And it just, as a sort of a direction of time limit, we say more than 5 years after the domestic remedies have been exhausted, might be too long, and more than 3 years from the conclusion of another procedure of international investigation or settlement. So for example, if you've gone through the European Court of Human Rights, they've declared it inadmissible, and then you want to go to the Human Rights Committee. If you wait more than 3 years, that's risky, unless there are reasons to justify the delay. Maybe, I don't know, a death of the main lawyer, or disease, sickness. Just things coming up in my mind. So pay attention to that limit. Try to do it as fast as you can after you have a decision that allows you to continue. Complementarity is an important aspect. Generally, a complaint is inadmissible if another international mechanism is examining or has examined the same matter. This is a little bit technical, and I can go into detail a bit more, maybe if people have specific questions about it. But basically, the idea is that the main idea behind it is that international bodies, to avoid that they contradict each other. So if you submit your case to both the European Court on Human Rights and the Human Rights Committee, and they come to a different conclusion, that's not great for the system. If the European Court on Human Rights has made a decision on your case and it has said that that it wasn't a violation, you then don't have the opportunity anymore to go to the Human Rights Committee, because you have a final decision of another international body. Just a little footnote on that. We are not talking about the special procedures of the United Nations. So the special rapporteurs, the independent experts that have either a thematic or a country mandate, those are not considered as international procedures for this rule specifically. What does a complaint result in? If they decide that it's not a violation, then everything ends there and your case is finished. There is no appeal after a decision from the Human Rights Committee. If they decide that there was a violation, they do specify remedies, and there are specific and several types of remedies that they can ask the state. Mostly it's about compensation. Although they will never say how much, they will usually say appropriate compensation. But what they also do is ask to adopt new laws, to implement training programs. And that is because sometimes a remedy includes that the state should guarantee non-repetition of the same offense. And they do become more specific over time. So now we have also a little bit more detail. Bring perpetrators to justice, for example, a retrial, a release of someone that was arbitrarily detained, medical treatment, etc. So that is what your complaint will result in if there was a violation. Of course, this is very specific to your case, and the committee will adapt the remedy to the specific facts of the case.
Is there anything you would like to add, Làzarie?
I just wanted to thank everyone for attending, and also specifically thank you to the interpreters. I don't speak Turkish, unfortunately, so it was what made it able for me to follow along. Thank you.
Indeed. Thank you all for being with us. That's